Can you briefly explain the current issues regarding AI-generated works and copyright IP laws across the world, also highlighting the recent issue in India related to OpenAI?
What publishers of um, news publications like New York Times, as well as authors, are saying is that AI systems, generative AI systems like ChatGPT, are trained on their works, and this usage of their works is unauthorized. And so they're saying, and for instance, in the New York Times complaint, they've also shown as evidence, that there have been like broad kind of um, not replications but reproductions of New York Times articles and verbatim. Now that litigation was some time ago, and since then, of course, OpenAI has started getting into licensing deals with different companies in the US. The ANI complaint is largely the same, except there's an additional issue of defamation that ANI has, brought forth. It's basically also filed a defamation suit against OpenAI because ChatGPT, I think, said something to the effect of ANI is kind of purveying fake news. So that is the sole kind of difference. But largely it's the same. Basically, there's publishers are saying that this is unauthorized use of our works. And I mean, there's many kinds of arguments that AI companies take. OpenAI in the New York Times case, for instance, use the Google Books case, saying that it's transformative and non-expressive use. Uh, Whereas over here, they've taken different lines. They've said, they've raised questions of jurisdiction. They've also said not only geographically, but also because there's a defamation suit that has been brought in as well. Um, and and they've said that the data is based in America, so there's no jurisdiction here, et cetera, et cetera. So, I mean, the way that they seem to be fighting this case over here seems to be somewhat different from how they've kind of fought litigations abroad, and that is also, I think, maybe has to do with the nature of copyright law here versus in the US. But we can get to that later.